Item 5. Principal makes oath that in the face of the unprofessional and willful nature of the woman calling herself Louise Henderson, I wrote to her ultimate boss, the man calling himself Robert McClellan, who was also acting in the capacity of Attorney General of the Commonwealth of Australia at the time. The lawful notice to Robert McClellan is in the file attachment named as follows: 03LN 2009-1022. Notice to Robert McClellan, PDF. What I will now do is read this notice into the public record and into evidence for this court, for this jury. This video stream will now transition to the reading of this lawful notice. I am now going to read into the public record and into evidence the lawful notice I sent to Robert McClellan on the 22nd of October 2009. So, from a free man commonly called Peter Andrew Nolan, standing in God's kingdom, and the address is just wiped out, to Robert McClellan, acting as the Honourable Robert McClellan, Attorney General, Attorney General's Department, Central Office, 3 to 5, National Circuit, Barton, Canberra, Australian Capital Territory, 2600, Australia. 22nd of the 10th, 09. Lawful notice to Respondent Robert McClellan, acting as the Honourable Robert McClellan, Attorney General, Attorney General's Department, Central Office, 3 to 5, Barton National Circuit, Barton, Canberra, Australian Capital Territory, 2600. And this was sent to him under oath and penalty of perjury and full commercial liability. Let right be done, though the heavens should fall. Notice to principal is notice to agent. Notice to agent is notice to principal. I, commonly addressed by the calling of Peter Andrew of the Nolan family, hereinafter the principal, in my correct public capacity as beneficiary of the original jurisdiction, being of majority in age, competent to testify, a self-realized and free sentient man, my yes be yes, my no be no, do state that the truths and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to the human being calling himself Robert McClellan, acting as the Honourable Robert McClellan, hereinafter known as the Respondent. This is an affidavit with respect to the order of sale of 8 Schofield Parade, Pennant Hills, between Jennifer Marguerite Nolan and Peter Andrew Nolan. Item 1. Principal is of legal age and competent to testify. Item 2. Principal has first-hand knowledge of the facts stated herein. Item 3. Principal makes oath that he has received an order dated the 16th of June 2008, issued by juristic person known as Judicial Registrar Johnson of a family court dispute brought by Jennifer Marguerite Nolan with respect to the sale of the house located at 8 Schofield Parade, Pennant Hills, New South Wales 2120, and a copy was supplied to Robert McClellan. 4. Principal makes oath that at the time of this order, solicitors for Principal Watts McRae had at no time provided written documentation nor made verbal comment to the effect that engaging a solicitor declared Principal a ward of the state. 5. Principal makes oath that at no time did the solicitors for Principal Watts McRae provide written documentation nor made verbal comment to the effect that the loyalty of Watts McRae and engaged solicitors was to the Law Society of Australia and to the Family Court by oath, and that they were acting in the best interests of the Law Society of Australia and were not acting in the best interests of Principal. 6. Principal makes oath that at the time of this order, solicitors for Principal Watts McRae had at no time provided written documentation nor made verbal comment to the effect that they may, at their discretion, without informing Principal, engage in side conversations with other members of the Australian Law Society to create circumstances beneficial to the Australian Law Society, which would also precipitate circumstances detrimental to Principal. 7. Principal makes oath that at the time of this order, solicitors for Principal Watts McRae had at no time provided written documentation nor made verbal comment to the effect that they had a clear conflict of interest in that as members of the Australian Law Society and under oath to serve the best interests of that society, their loyalty to the Australian Law Society conflicted with the interests of principal. 8. Principal makes oath that on the day of March 7, 2008, Principal met with the representatives of Watts McRae. Principal makes oath that he had serious concerns as to the poor performance of Watts McRae in his estimation, specifically with respect to refusal to pass along requested communications and specifically challenge the effectiveness of representation. 9. Principal makes oath that representatives of Watts McRae made many verbal comments to the effect that they were working to represent Principal's interests, quote, effectively, unquote. 10. Principal makes oath that a Watts McRae representative, namely Jacqueline Vincent, used words to the effect, quote, do you have confidence in our firm to represent you most effectively to the court, unquote, in asking Principal specifically if he had confidence that Watts McRae would effectively represent Principal's best interests. 11. Principal makes oath that he was under the impression that every effort was being made by Watts McRae representatives to assure him his best interests were being represented. 12. Principal makes oath that he felt at that meeting there was something wrong and that some deception was being perpetrated upon him. However, he could not comprehend what that deception might be. 13. Principal makes oath that at the time he was well aware that under commercial law, any contract or any performance of duties that are performed in deception as a result of deception are null and void and can be redressed via legal processes at a later date. Therefore, Principal determined that the course of action to pursue was to allow the deception to stand and to continue with the engagement of Watts McRae and deal with the deception at a later point in time. 14. Principal makes oath that when he was asked to consent to the sale of his property, that he gave clear and unambiguous written instruction to Watts McRae that he did not consent to the sale of his property. 15. Principal makes oath that his property was subsequently sold without his consent, subsequent to an order issued by Judicial Registrar Johnson, copy enclosed. 16. Principal makes oath that he has proposed remedy for what he sincerely believes was the unlawful sale of Principal's property because it was achieved by deceit. This remedy is a bill for the order placed to the value 10 times the proceeds of the order, namely 5.5 million Australian dollars. 17. Principal makes oath that he has written to the human being calling him or herself Judicial Registrar Johnson, also acting as a judicial person known as Judicial Registrar Johnson, and I sent it to the Garfield Barwick Commonwealth Law Courts building until I found out where that person was, and I sent another copy there. And I've written to them in a peaceful and lawful attempt to enter into lawful exchange of notices to address the issue of unlawful sale of property achieved by deceit. Principal makes oath that no known response has been forthcoming and copies are enclosed. Principal makes oath that he has written to the human being calling herself Louise Henderson, also acting as Federal Magistrate Louise Henderson, in the Garfield Barwick Commonwealth Law Courts building in Parramatta, in a peaceful and lawful attempt to enter into a lawful exchange of notices to address the issue of unlawful sale of property achieved by deceit. Principal makes oath that no known response has been forthcoming and copy was supplied to Robert McClellan. 19. Principal makes oath that he has filed a UCC1 financing statement to become the primary creditor and secured party of the corporation known as Mr. Peter Andrew Nolan, incorporated on the 11th of the 1st, 1964. 20. Principal makes oath that he sincerely believes that he has a higher claim to all property of the corporation known as Mr. Peter Andrew Nolan, incorporated on the 11th of the 1st, 1964, than has the private run-for-profit corporation known as the Australian Federal Magistrates Court, on the basis of being the primary creditor and secured party for that corporation. And a copy of the UCC1 financing statement was enclosed. 21. Principal makes oath that he wishes to engage in lawful exchange of notices and in a professional and peaceful manner, such that this issue of the unlawful sale of property be dealt with. Principal says not, signed by me, this 22nd day of the 10th month, that's a mistake, 2010, so 22nd of October 2010, near London, England. I had it witnessed and signed by 3 people, 22nd of the 10th, 09. Their signatures are hidden from the public. Notice of intent and proposed remedy. This section of this document provides a notice of intent and proposed remedy, inviting the respondent to peacefully and without dispute cordially resolve the matter at hand, that being the distribution of funds from the proceeds of the sale of the house known as 8 Schofield Parade, Pennant Hills, New South Wales 2120. The 2 parties with whom Principal has attempted lawful and peaceful communication have, to the best of the Principal's knowledge, chosen to go into lawful dishonour. It is the Principal's wish that this current situation be resolved peacefully and expediently. The respondent, acting in the role of Attorney General for the corporation known as the Commonwealth of Australia, carries responsibilities and obligations to ensure that subordinates meet their legal and lawful obligations or are penalised according to accepted norms of common law. These 2 parties being Judicial Registrar Johnson and 2 Federal Magistrate Louise Henderson. It is this Principal's wish to engage in lawful conversation, parties responsible and accountable to the respondent in order to resolve this matter, this current matter of the unlawful appropriation of the property of the corporation Mr. Peter Andrew Nolan, incorporated on the 11th of the 1st, 1964, which is fully owned and due to the human being Peter Andrew of the Nolan family. Principal, by way of the Principal being the primary creditor and secured party for Mr. Peter Andrew Nolan, incorporated on the 11th of the 1st, 1964. It is this Principal's wish that the respondent respond to this lawful notice to nominate himself or delegated parties whom he will hold accountable for the proper and appropriate completion of the matter at hand. The time allocated for response to this lawful notice is 20 days from the date of issuance of the lawful notice. Should the respondent be unable or unwilling to enter into peaceful and productive exchange of lawful notices, or unable or unwilling to nominate an authorised representative to enter into peaceful and productive exchange of lawful notices in the 20 days allocated, the following remedy is proposed. 1. A penalty of 1 troy ounce of 99.99% pure gold per day be applied for dishonour and non-response. The Attorney General is the highest office in the land for this matter, and this Principal expects the respondent to meet his obligation in ensuring his subordinates act lawfully in a timely manner. 2. Principal to convene a de jure jury to hear the facts of the matter, and the de jure jury to pass judgment on the respondent for failure to exercise his obligations to ensure his employees act in accordance with the common law of the land called Australia. 3. All said proceeds of the property known as 8 Schofield Parade, Pennant Hills, New South Wales 2650, Australia, some $293,000 currently held in a controlled account at Watts McRae, contact Justin Dowd, be transferred to a bank account of the Principal's choosing in a default judgment. 4. All time of Principal and all incurred expenses which are required to be expended in order to pursue authorised representatives communicate with Principal in an exchange of lawful notices will be billed directly to respondent as the authorised representative responsible for ensuring timely response to lawful notices of his subordinates. Principal advises respondent that non-response is considered dishonour under law, and that Principal reserves the right to generate default judgments or convene a court de jure to pursue remedy should respondent go into dishonour. Non-response will be considered acquiescence. Yours sincerely, signed by me, that's my signature, 22nd of the 10th, 09. This concludes the reading into the public record and into evidence for this jury the notice to Robert McClellan of 2009-10-22. Thank you for listening. Item 6. Principal makes oath that I am in the sincere belief that the communications that were sent to Louise Henderson and the man calling himself David Dunkley, and the man calling himself Robert McClellan were received by their intended recipients. The evidence that the communication was received by Louise Henderson and David Dunkley is the fact that in the court order he wrote, David Dunkley refers to a, quote, barrage of email, unquote, attempting to slur me for the mere act of attempting to communicate with Louise Henderson and David Dunkley. The jury is reminded that Louise Henderson and David Dunkley are paid from the public purse, and that makes them our servants and us their masters. You might want to ask David Dunkley, how dare he attempt to slur his master for attempting to communicate with him? You might want to ask David Dunkley why he was such an unprofessional and willful servant that he did not answer his master when his master attempted to communicate with him. I suggest you members of the jury ask him that. Item 7. Principal makes oath that on the date of November 24th, 2009, I went to the Australian Federal Magistrates Court in Parramatta, Sydney, and spoke with a man who called himself Paul the Large. Paul claimed to be the registrar for the building and the courts. I wished him to deliver a set of documents to both Louise Henderson and David Dunkley. These were a copy of the documents I would be bringing with me on Thursday, the 26th of November 2009, to my court meeting with whoever turned up. Paul and I discussed this situation for a period of about 15 minutes. Paul refused to give me his word he would deliver these documents. Paul the Large has a case to answer for as well. We will get to him in good time. Item 8. Principal makes oath that on the date of November 24th, 2009, the following documents were delivered by me personally to Paul the Large. Paul the Large claimed he gave these documents to the respective parties. The two key documents presented were the default judgments for the proceeds of my house, which was stolen by selling the house against my express non-consent and then stealing the proceeds of the house and placing the proceeds in an account at Watts McRae Family Law Lawyers. The documents delivered are presented in the file attachments named as follows: 09, proceeds for house plus theft, and 11, payment for house. What I'm going to do now, there are 4 default judgments which were rendered on that day. One of them is to Louise Henderson, which is a default judgment mandating that she hand back the $293,000 which is in the Watts McRae account as a default judgment due to non-response. So what I want to be very sure that you, the jury, understand as this evidence is presented to you is that on the 24th of November 2009 I gained a default judgment from a notary public in Parramatta, signed, sealed, delivered default judgment against Louise Henderson for the retention of the proceeds of my labour. Okay? So legally and lawfully, from the time that default judgment was signed, the 24th of November 2009, nobody from the Commonwealth of Australia or the Australian Federal Magistrates Court had any right to retain my property. Nobody. So this default judgment will be read into evidence now. You will see this default judgment read into evidence. This default judgment, notarized by a Commonwealth of Australia notary, means I owned that property at that point in time in every respect, and it was not challenged by anybody. So that David Dunkley pretended 2 days later to have the authority to disperse the proceeds of my labour was an absolute lie, and I have the default judgment signed by a Commonwealth of Australia notary that proves that lie. So you, the jury, are now going to see this default judgment read to you, and what I want you to understand is what that means is nobody from the Commonwealth of Australia had presented any proof on an affidavit under penalty of perjury the proof of their claim that they could retain this property. Therefore, it was my property. Okay? So right now, this video stream is going to transition to the reading of all the default judgments generated, one of which is a default judgment to Louise Henderson. I shall now read into the record the notarized default judgments following on from the prior video presentation. This first one is actually for Louise Henderson and not for the respondent, Jennifer Marguerite Toll. However, I am reading it into the record at this point in time because I want you, the audience, in the Jennifer Marguerite Toll case, the audience and the jury, the public and the jury, to see that a default judgment was issued against Louise Henderson for the theft of my house. In the case with Louise Henderson, that information will be, of course, included. So I shall read this. I went and got the default notices notarized by a public notary, Stuart Lawrence Niven of 91 George Street, Parramatta. He's a public notary, authorised and sworn, practising in the city of Parramatta in New South Wales. This notice was served on Louise Henderson. Okay? So in the first instance, I will read the entire form and then I will just go through each default judgment. So each of these default judgments has got the same information at the front of it from Stephen Lawrence Niven. Okay, so Form 3, General Certificate as to execution of documents in presence of a notary as witness. So I signed them, he notarized them. Parramatta, New South Wales, Commonwealth of Australia. To all to whom these present shall come. I, Stuart Lawrence Niven of 91 George Street, Parramatta, public notary, duly authorised, admitted and sworn, and practising in the city of Parramatta, in the state of New South Wales, in the Commonwealth of Australia, do hereby certify that I was present on the 24th day of November in the year 2009 and did see Peter Andrew Nolan, the person named in hitherto annexed, duly signed, seal and evidence, the said affidavit, and that the name thereto subscribed is in the proper handwriting of said Peter Andrew Nolan, and that the same Stuart Lawrence Niven thereto subscribed as the witness. Thereto is the proper handwritings of myself, Stuart Lawrence Niven of 91 George Street, Parramatta, New South Wales, Australia, the subscribing witness hereto, in faith and testimony whereof I have hereto subscribed my name and affixed my seal of office at Parramatta, aforesaid this 24th day of November in the year 2009. Stuart Lawrence Niven's signature, that's his seal. Okay. Now I made the mistake of giving the originals to Jennifer and keeping the copies, but such mistakes happen. Clearly this is being presented to a jury. Clearly I had this done, and if you want to call Stuart Lawrence Niven to testify or make a statement, you're welcome to do that. So, lawful notice to the respondent, 24th of November 2009. Lawful notice to respondent, the human being calling herself Louise Henderson. So this was addressed to Louise Henderson. And what I'm doing now, I signed it under oath on the 24th of November 2009. I am now reading it into evidence as evidence against Jennifer Marguerite Toll that this was served on Louise Henderson. And that on the 24th of November 2009, Louise Henderson was issued a default judgment of guilty for stealing my house. Therefore, on the 26th of November 2009, David Dunkley had no right to even be discussing or negotiating my house, which I owned due to this default judgment, okay, which I had claimed back correctly and properly through a claim of right. So I had issued my claim of right in September 2009. I'd served notice on Louise Henderson to prove that she had any right to sell my house and take the proceeds of my labour, which was my property, and put it into a bank account at Watts McRae and keep it from me. Okay? She failed to respond to that affidavit. I am quite happy to say under oath that she failed to respond to that affidavit, and this default notice was issued. From the time I signed this default notice, The Commonwealth of Australia had no lawful or legal right to do anything with my property. With the signing of this document, Louise Henderson was guilty of theft of my property. Okay, the 24th of November 2009. Now it says, I, commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal in my correct public capacity as beneficiary of the original jurisdiction, being of majority in age, competent to testify, a self-realised and free sentient man, my yes be yes, my no be no, do state that the truths and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to the human being calling herself Louise Henderson, also acting as Federal Magistrate Louise Henderson, hereinafter known as the respondent. Affidavit with respect to the unlawful theft and sale of 8 Scafell Parade Pennant Hills between Jennifer Marguerite Nolan and Peter Andrew Nolan. So, firstly, principal is of legal age and competent to testify. 2. Principal has first-hand knowledge of the facts stated herein. 3. Principal makes oath that he placed a copy of the attached affidavits and notice of intent and remedy into the British Royal Mail as registered mail addressed to the respondent at the address on the Australian Family Court in George Street, Parramatta on September the 23rd, 2009 and October 23rd, 2009. Principal makes oath that he is not in receipt of this lawful notice by return mail and therefore sincerely believes that the lawful notices were duly presented to the respondent. Principal makes oath that he has also sent many faxes to the listed fax number for the respondent in a further effort to offer the hand of peace in discussing and negotiating an amicable resolution to the issues at hand. The fax number used was 6102-9893-5600. Copies of the transmissions and receipt can be presented as evidence should the respondent wish. Principal has not seen or been presented with any material fact or evidence that show respondent has any lawful right to the proceeds of the property known as 8 Scafell Parade, Pennant Hills, New South Wales 2120 and believes sincerely that none exists. Louise Henderson never presented any material facts or evidence to show that she had any right to retain the proceeds of that property. It has never been shown, not by Louise Henderson and later on not by David Dunkley. But remember, this is the date of this affidavit is the 24th of November 2009, 2 days before the court meeting, a default judgment saying that Louise Henderson had never shown this information. You can see that I've signed it. You can see Notary, Commonwealth of Australia. Okay? This was signed and notarized by a notary in the Commonwealth of Australia. So you people sitting on the jury, this is a legally binding document. It is a default notice. It's notarized by a notary in the Commonwealth of Australia. Louise Henderson owed me my house back. Okay? And this stands up in any court in the land, in fact. Now you are a common law court. If you have a question as to the validity of this, you can discuss it with the expert in common law. He will tell you that it's valid. So the notarial notice of non-response and default judgment. To date, respondent has given no response to the September 23rd, 2009 entitled Affidavit with respect to unlawful theft and sale of 8 Scafell Parade, Pennant Hills, between Jennifer Marguerite Nolan and Peter Andrew Nolan, and has received no response from a similar affidavit placed in the Royal Mail on October 23rd. Copies of documents provided are included in the envelope with this affidavit, and that's what I did. I gave her copies of those documents. The period for lawful response for both these affidavits has expired. Okay, so I offered Louise Henderson an opportunity to respond and say, show me the evidence you have for retaining the proceeds of my property, and that expired. In all systems of law, silence is consent. Non-response is to admit guilt. Okay, so Louise Henderson is guilty of stealing my house on the 24th of November 2009. This notarial notice is to advise respondent that respondent's failure to respond has resulted in an automatic default judgment and permanent irrevocable estoppel by acquiescence, barring the bringing of any future claim of defence against this default judgment. So Louise Henderson cannot defend this. The default judgment issued is that given the respondent was not willing to rebut the affidavit or to provide proof of claim that she had lawful right to retain the proceeds of the property known as 8 Schofield Parade, Pennant Hills, New South Wales 2120, the respondent is hereby required to immediately on receipt of this default judgment issue the appropriate paperwork order to transfer all proceeds of the property known as 8 Schofield Parade, Pennant Hills, New South Wales 2120, an amount of approximately $290,000 held with Watts McRae to the following bank account. And that was my St. George bank account at the time. Failure to immediately, meaning 5 p.m. Wednesday, 25th of November 2009, immediately, the next day. Failure to immediately obey this default judgment will result in a further remedy default judgment of $10 million being levied against the respondent to be paid from the respondent's personal property. Respondent is required to notify principal of the issuance of said paperwork via means described in the notice of communication and documented fax number immediately the paperwork is issued. No fax on that fax number will be interpreted that the respondent has refused to comply with its lawful default judgment. Both this judgment and this further remedy default judgment may result in one or more of the following. 1. A lien against the personal and commercial businesses and property of the respondent. A writ of execution to recover the amount of $290,000 from respondent's personal property. A writ of execution to recover the amount of $10 million from the respondent's personal property. Further, the respondent is hereby charged with the common law crime of theft. The principal shall, at his earliest convenience, impanel a court de jour and present facts of the matter to a court de jour. The court de jour will decide what penalty, if any, to impose on the respondent for the common law crime of theft. You can see I've signed it, and you can see that Stuart Lawrence Niven has notarized it. Okay? So the reason I wanted to read this into the record, and you can see the date 24th of the 11th, 09. The reason I wanted to read this into the record for the case against Jennifer Marguerite Toll is this document proves that as of the 24th of November 2009, ownership of the proceeds of the $290,000 thereabouts from the property of 8 Schofield Parade, Pennant Hills was my property, even according to the legislation of the Commonwealth of Australia. Okay? My property. Nobody produced any evidence that said otherwise. So they defaulted, and that is my property. Okay? Now, next thing is I'm going to read the other 3 default judgments. You can see this, the first page is the same. This is the default judgment for the repayment of fees, I believe, for Philip Lee. Okay. So, lawful notice to respondent, Miss Jennifer Marguerite Nolan, with her address. I shall read the whole thing in again because this is testimony under oath. So, I, commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal in my correct public capacity as beneficiary to the original jurisdiction, being of majority in age and competent to testify, a self-realized and free sentient man, my yes be yes, my no be no, to state the truth and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to Jennifer Marguerite Nolan, hereinafter known as the respondent. Affidavit with respect to payment of fees to Philip Lee. 1. Principal is of legal age and competent to testify. 2. Principal has first-hand knowledge of the facts stated herein. 3. Principal makes oath that he placed a copy of the attached affidavit and notice of intent and remedy into the Irish Mail as registered mail addressed to respondent at the current address of the respondent. That is the affidavit that you saw me read into the record just a little while ago. Okay? Principal makes oath that a short time later, said mail was sent to the return to sender address and was seemingly refused for collection. Principal was not aware if respondent had moved house. Principal makes oath that he was subsequently emailed a financial statement from respondent's Australian family law solicitors which continued to have the above address for the respondent. So it looks like the respondent returned the document, returned to sender, refused to accept it, and you can't refuse to accept an affidavit. Okay, when it's delivered to you in your area, in your place of residence, that is served. If you return it to sender, that's your bad luck. Principal makes oath that he was subsequently emailed a financial statement. Oh, sorry, I just read that. So she was still living at the address, she just sent it back. So principal makes oath that he is in the sincere belief that he made every effort to lawfully and peacefully present the affidavit and notice of intent and remedy by firstly approaching a professional service agent who declined, and then sending the notice by registered mail. So I approached a professional service agent in Ireland and offered him €100 to deliver this document, and he said no because of the contents of the document. Okay, so I was required to send it by registered mail because, of course, if I turned up at Jennifer's house, she would call the police and have me arrested and thrown in jail. Okay, so she was sent. I tried to get a serving agent to serve it. I was refused. I sent it via registered mail. It was turned away. If I went there myself, I would most likely be arrested and incarcerated. So I made every effort to serve that document on Jennifer peacefully. She refused to accept it, and so you, the jury, can decide whether she should have accepted it or not. Okay? The principal makes oath that he was in fear of kidnap and incarceration should he attempt to go to the address listed and serve the document himself. Jennifer has a history of having me kidnapped and incarcerated by making false allegations to police. 8. Principal makes oath that respondent has previously had him unlawfully kidnapped and incarcerated, and respondent has noted in her subsequent affidavits that she contacted the criminal element called the police in Ireland to determine if she could further have principal kidnapped and incarcerated unlawfully. I make that under oath. Principal has not seen or been presented with any material facts or evidence that show respondent has any lawful right to refuse to accept lawful notices when presented in peace by the registered mail and believes sincerely that none exists. Principal has not seen or been presented with any material fact or evidence that show responsible has any lawful right to retain possession of the fees which were legally and lawfully accumulated against the Instant Business Intelligence Company in an effort to defend the company from the actions of respondent and believes sincerely that none exist. So Jennifer has never produced evidence as to why she can do this, and she's required to produce evidence of that. In absence of evidence, I'm making the presumption that she can't do that. You can see that I have signed it. You can see it was the 24th day of November 2009 near Sydney, Australia, and you can see it was notarized by Stephen, what's his name? Notarized by Stuart Lawrence Niven. You can see it was notarized. Okay. Notary Public, Commonwealth of Australia, done deal. So, notarial notice of non-response and default judgment. To date, respondent has given no response to the affidavit with respect to payment of fees to Philip Lee and the attached notice of intent and proposed remedy issued by the principal and claimant addressed by the calling of Peter Andrew Nolan, a free man, within 10 days time period. This notarial notice is to advise respondent that respondent's failure to respond has resulted in an automatic default judgment and permanent and irrevocable estoppel by acquiescence, barring the bringing of any future claim against this default judgment. The default judgment issued is that given to the respondent. The default judgment issued is that given the respondent was not willing to rebut the affidavit or apply her signature to pay the fees as proposed in the remedy, the respondent has hereby forfeited her right to being a signatory to the fees payable, and that the fees have become sole property of the principal to disperse the payment of these fees to Philip Lee. Meaning, I get the money from the house and I pay Philip Lee because she refused to pay Philip Lee. This default judgment has higher status in law than the private run-for-profit company calling itself the Australian Federal Magistrates Court. Okay? An authorised representative of the private not-for-profit company calling itself the Australian Federal Magistrates Court is hereby instructed to issue orders to transfer the amount of $36,800, meaning 23,000 euros, to the following bank account. Okay, meaning Louise Henderson, but she didn't do it. From this account, principal makes oath to forward the full amount to Philip Lee's solicitors. Okay, this amount was never transferred. You can see I've dated it again. Stuart Lawrence Niven has witnessed, signed, notarized. This document may be used in a judicial proceeding. That's what this is. This is now being presented to a common law court. That's what it's being presented to. This document is being used in a judicial proceeding. Next, this is a default judgment for the loan given to me by my brother Christopher. Okay, again, notice, and these, I will just say, these notices were handed personally to Jennifer in the court meeting. Okay, as she walked into the courtroom, she was served these notices. And I'm prepared to say under oath, I served these default judgments on her as she walked into the court meeting. So as she walked into the court meeting, she was served the default judgment for Louise Henderson that said, I owned the entire proceeds of the house. Okay? So before the court meeting, before she got into the room, she was served that default notice. And I want to make that very clear. Jennifer was in possession of the default notice that I owned the entire amount and property of the house before walking into the courtroom. Okay? So this is the affidavit with respect to repayment of loan by Christopher Nolan. I, commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal in my correct public capacity as beneficiary to the original jurisdiction, being of majority in age, competent to testify, a self-realized and free sentient man, my yes be yes, my no be no, do state the truths and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to Jennifer Marguerite Nolan, hereinafter known as the respondent. Affidavit with respect to repayment of loan by Christopher Nolan. Item 1. Principal is of legal age and competent to testify. Item 2. Principal has first-hand knowledge of the facts stated herein. Item 3. Principal makes oath that he placed a copy of the attached affidavit and notice of intent and remedy into the Irish mail as registered mail addressed to respondent at the current address of the respondent. The affidavit and notice of intent read previously into evidence. Principal makes oath that a short time later said mail was sent to the return to sender address and was seemingly refused for collection. Principal was not aware if respondent had moved house. Principal makes oath that he was subsequently emailed a financial statement from respondent's Australian Family Law solicitors which continued to have the above address for the respondent. Principal makes oath that he is in the sincere belief that he made every effort to lawfully and peacefully present the affidavit and notice of intent and remedy by firstly approaching a professional service agent who declined and then sending the notice by registered mail. Principal makes oath that he was in fear of kidnap and incarceration should he attempt to go to the address listed above and serve the document himself. Principal makes oath that respondent has previously had him unlawfully kidnapped and incarcerated, and respondent has noted in her subsequent affidavits that she contacted the criminal element called police in Ireland to determine if she could further have principal kidnapped and incarcerated unlawfully. Principal has not seen or been presented with any material facts or evidence that show respondent has any lawful right to refuse to accept lawful notices when presented in peace by the registered mail and believes sincerely that none exist. 10. Principal has not seen or been presented with any material fact or evidence that shows respondent has any lawful right to retain possession of the personal loan made by Christopher John Nolan to principal and believes sincerely that none exists. So Jennifer has never presented any evidence that she had any right to retain the loan made to me by my brother Christopher John Nolan. You can see I have signed it. You can see it's the 24th day of the 11th month 2009, the 24th of November 2009, signed by Stuart, sealed by Stuart, a notary public in Australia. So the notarial notice of non-response and default judgment. To date, respondent has given no response to the affidavit with respect to repayment of loan by Christopher Nolan and the attached notice of intent and proposed remedy issued by principal and claimant addressed by the calling of Peter Andrew Nolan, a free man, within the 10-day time period. This notarial notice is to advise respondent that respondent's failure to respond has resulted in an automatic default judgment and permanent and irrevocable estoppel by acquiescence, barring the bringing of any further claim against this default judgment. She has accepted this default judgment, that means. The default judgment issued is that the respondent was not willing to rebut the affidavit or apply her signature to repay the loan as proposed in the remedy. The respondent has hereby forfeited her right of being a signatory to the claimed money, and that the claimed money has become sole property of the principal to disperse the repayment of this loan to his brother. The default judgment has higher status in law than the private run-for-profit company calling itself the Australian Federal Magistrates Court. An authorised representative of the private run-for-profit company calling itself the Australian Federal Magistrate Court is hereby instructed, Louise Henderson, to issue orders to transfer the amount of $50,000 to the following bank account. That's my bank account number. From this account, principal makes oath to forward the full amount to Christopher John Nolan. Christopher John Nolan is reluctant to personally involve himself in these proceedings and wishes his bank account details not be made known to those who might well do him harm. Signed by me, 24th of November, noted by Stuart Lawrence Niven, signed by Stuart Lawrence Niven, sealed by Stuart Lawrence Niven. This document may be used in a judicial proceeding, which is exactly what is happening. Okay, so Jennifer waived the right to have her signature applied to this loan. She's stealing this $50,000. She stole this $50,000. So this one is for, just go down here. This one is actually for a gentleman by the name of, or a person, I believe it's a gentleman, by the name of Registrar Johnson. Okay, so when they stole my house, the person who signed the document to steal my house was one Registrar Johnson, Judicial Registrar Johnson. Okay, so this default notice was also sent to Judicial Registrar Johnson in this building. And I want to read this into the record in Jennifer's case because, again, this was sent on the 24th of November 2009, again notarized by Stuart Niven. So the lawful notice to the respondent, Registrar Johnson, and I'll read the whole thing. This is again to indicate that at the time, on the 24th of November 2009, the Commonwealth of Australia, as represented by the Australian Federal Magistrates Court, did not own my property, had no lawful claim to my property. Okay? So I, commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal in my correct public capacity as beneficiary of the original jurisdiction, being of majority in age, competent to testify, a self-realised, free sentient man, my yes be yes, my no be no, do state the truth and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to the human being calling himself, him or herself, I don't know, Judicial Registrar Johnson, also acting in the judicial person known as Judicial Registrar Johnson, hereinafter known as the respondent. Affidavit with respect to order for the sale of 8 Schofield Parade, Pennant Hills, between Jennifer Marguerite Nolan and Peter Andrew Nolan. This Judicial Registrar Johnson was the person who signed the order for the sale. Okay? The sale of the house, and had no right to do so. Never at any point had any right to do that. Okay? Because that right was claimed by deception. 1. Principal is of legal age and competent to testify. 2. Principal has first-hand knowledge of the facts stated herein. 3. Principal makes oath that he placed a copy of the attached affidavit and notice of intent and remedy into the British Royal Mail as registered mail addressed to the respondent at the address of the Australian Family Court in George Street, Parramatta. Actually, I sent it to the other building. Principal makes oath that this mail was never received at the return address and sincerely believes in good faith that this mail was presented to the respondent. So sooner or later we have to put Registrar Johnson on trial. The principal has not seen or been presented with any material fact or evidence that show respondent has any lawful right to refuse to pay his bill for the order that was issued and believes sincerely that none exists. So this registrar issued an order, I gave him a bill for that order, and he has not paid the bill. Okay, 6. Principal has not seen or been presented with any material facts or evidence that show respondent has any lawful right to order the sale of his house and believes sincerely that none exists. Okay, so I challenged Registrar Johnson to show me on what basis he or she had any right to sell my house, and they did not present any evidence of that. Okay. Now, Justin Dowd claimed time and time again that they had every right to sell my house, but the speech by Robert McClellan will put an end to that notion. Okay. Again, you can see I signed it. It was the 24th of November. You see Stuart Niven signed it, notarized it as a notary public, and stamped it. So the notarial notice of non-response and default judgment. Okay. To date, the respondent has given no response to the affidavit with respect to order for sale of 8 Schofield Parade, Pennant Hills, between Jennifer Marguerite Nolan and Peter Andrew Nolan, and the attached notice for bill of services ordered. Okay, so I sent him a bill of services ordered, issued by the principal and claimant, addressed by the calling of Peter Andrew Nolan, a free man, within the 20-day period. Printed copies are included for your information, so I packaged this up and gave it to them. This notarial notice is to advise respondent that respondent's failure to respond has resulted in an automatic default judgment and permanent and irrevocable estoppel by acquiescence, barring the bringing of any future claim against this default judgment. That is, you're guilty. You cannot claim against this judgment. This default judgment is issued. The default judgment issued is that given the respondent was not willing to rebut the affidavit or to pay his lawful bill for his lawful order, the respondent is hereby judged to have acquiesced to the bill for $5.5 million, and this bill is now due immediately upon receipt. Immediate payment can be made to the following bank account, right? So I sent a bill for $5.5 million to Registrar Johnson. Okay, now of course he doesn't have that money. Okay, but this is where it's going to get interesting now, because you, the jury, can ratify this and say he didn't respond. He issued an order. He must find out the amount for his order before he issues it. Pay the $5.5 million. So failure to pay this bill on presentation of this default judgment may result in one or more of the following: a lien against the commercial, business and property of the respondent, a writ of execution to recover the amount of the bill from the respondent, common law criminal charges of theft to be presented to a court de jure, and for the court de jure to be charged with the responsibility of deciding innocence or guilt, and subsequent punishment of the respondent for not paying his or her lawful bills. Okay? So that's what's going to happen to Registrar Johnson. But this is to note that having sold my house, I sent him a bill. You see me autograph. It's the 24th day of November, Stuart Lawrence Niven, his signature, stamp. Okay? This document may be used in a judicial proceeding, which is exactly what it's being used for. It is being used to present this affidavit to the jury that is putting Jennifer Marguerite Toll on trial for her part in the theft of my house. Okay? So that ends the reading of the default judgments. Thank you very much for listening. Item 9. Principal makes oath that on the date of November 25th, 2009, I also put a copy of all documents into the Australian mail system as registered mail. The evidence I did this is presented in the file attachments named as follows: 05L 2009-11-2501, David Dunkley cover, David Dunkley receipt, and just PDF, which is the letter. So 5, 6 and 7. If we go to the cover, you'll see this is the cover of the envelope that I put into the registered mail, and this post office was about 100 metres from the courts. Warning: common law lawful notices opening this envelope by other than the addressee may be subject to a de jure court for the crime of tampering with the mail of the land. 2. The human being calling himself David Dunkley, also acting as Federal Magistrate David Dunkley, Garfield Barwick Law Courts Building, 1 to 3 George Street, Parramatta, New South Wales 21550. Here is the receipt. It was sent by Express Post Platinum to Federal Magistrates Court, attention of David Dunkley, 1 to 3 George Street, Parramatta, New South Wales 2150, on the 25th of the 11th 09. You can see it's stamped, and you can see the sender to keep serial number there. And what I said to him in this letter was as follows. Date 25th of the 11th 2009, follow on from delivery of lawful notice. Dear human being calling himself David Dunkley, salutations. I came to the Garfield Barwick building on November 24th to deliver the attached documents to you. It seems that the staff in your building are not aware of the common law of the land in Australia. They keep talking about the rules, which they then openly admit were with respect to the corporation calling itself the Commonwealth of Australia. It seems that Damien, Din Tran and Paul the Large are also all committed to making sure that you do not get a copy of these documents. You have made yourself a very hard man to communicate with, David. Why would that be? You are, in the end, merely a private employee of a privately held run-for-profit company offering your adjudication services like McDonald's offers hamburgers. Your intransigence in accepting or responding to communications is being posted to freeman groups, including your name. You have no special privileges or rights of anonymity. You are a servant of the people of the land called Australia, but you are not being a very obedient or helpful servant. Why is that? And of course, David Dunkley has never answered those questions to me, so you, the jury, might like to ask him these questions. Okay? You might like to ask him why he was so intransigent. Item 10. Principal makes oath that on the date of November 26, 2009, a Thursday, I went to the Australian Federal Magistrates Court in Parramatta, Sydney. I went with head held high. I went into battle to do my bit, just like many Anzacs before me stormed the beaches at Gallipoli, or fought like demons in Tobruk, or fought in the hell that was the Kokoda Trail. Many Australian men died for my freedom. Many men died defending my parents and their generation when they were defenceless children. In 1940, my father was 3 and my mother was 1. Now, here I was, with a tyranny being introduced by treasonous traitors who call themselves Australians. It was my turn to, quote, storm the enemy lines, unquote. Only I was afforded the comfort of an air-conditioned room, and my weapons were my voice and a video recorder. I was spared deserts, jungles, bullets and bombs, but the situation was very much the same. I was putting my life at risk, and I knew it. The New South Wales Police and ASIO have killed many a man like me. I know it, they know it, and now you know it too. Men like my step-grandfather took vows to face all enemies, foreign and domestic, and on November the 26th, 2009, I took my place next to those brave Anzacs prepared to put my life on the line against a domestic enemy, the legal fraternity in the form of one David Dunkley and the Australian Federal Police by the first name callings of Christopher and Andrew. Item 11. Principal makes oath that at or about 9:50 a.m. on the morning of the 26th of November 2009, Paul Lalage came to see me outside the courtroom and told me two things. One, that he had given my documentation to David Dunkley and Louise Henderson. Two, that he had asked for 2 Australian Federal Police officers to attend the meeting so that there would be, quote, no trouble, unquote. I assured Paul that today I had come in peace. I was here to collect evidence, not to use force. He expressed pleasure at this comment. I then went over to introduce myself to the Australian Federal Police officers and explain to them what I was doing here today and why I was doing it. I told them I had come in peace and I was here to talk. They seemed reassured that I had approached them politely and professionally. Item 12. Principal makes oath that at or about 10:05 a.m. an administrative assistant called for the legal entity Mr. Nolan to enter the room. Item 13. Principal makes oath that the video recording that is provided as an attachment is the true record and only true record of what was said inside that courtroom. The transcript was altered in a criminal act and had to be reissued. There are still false statements in the transcript. Principal makes oath that all words he spoke are on the video recording. The slightly false transcript is available in the attachment named as follows: 13 Transcript of Court Meeting. Note to the jury: I have prepared a commentary on the transcript of the court meeting, and this will now be read into evidence. I also recommend that you watch the full video of the court meeting with the transcript on the screen as well as the transcript in front of you so that you can follow along with what happened in the court meeting. Remember, I flew from London to Sydney to get this 40 minutes worth of video to bring out the irrefutable proof of the criminality of the legal system of Australia. David Dunkley commits crimes in this courtroom, in this discussion, and 2 Australian Federal Police officers were warned that he was going to commit the crime of impersonating a public officer, and they refused to do anything about it. This video you are about to see is the single most damning piece of video in existence in Australia, which demonstrates irrefutably the criminality of the legal system and the police in Australia. This is very serious stuff. So this video stream will now transition to the reading, the commentary of the court transcript, and then you will see the court meeting itself. Okay, I'm now going to read into evidence not the entire transcript of proceedings. There is a video which I recommend you watch. As a jury member, I recommend you watch the video with the transcript attached, or have the transcript sitting next to you while you watch the video. It's a relatively short video. It's only 40 minutes long, and I flew from London to Sydney return to capture that 40 minutes of video. That 40 minutes of video is the single most important piece of video evidence existing in Australia, which demonstrates the criminality of the Australian Federal Magistrates Court. The most important demonstration of the criminality is right towards the end of the video, and it is where David Dunkley refuses to answer the question, are you serving under oath today? Twice. Now, you are sitting on the jury, you may not understand this, so I will explain it to you, okay? And you can verify this with any police officer, basically, or your expert in common law who will be assigned to you by the secretary. That is, if you are a public officer, let's say a police officer or a magistrate, you hold that office under an oath of office. That is, to become a magistrate, you must make an oath. And when you are serving in the public office of that magistrate, you must be serving under oath. You are to have your oath with you at all times. You are supposed to carry the actual oath around with you. And when you are presiding as a judge or a magistrate in your court, your oath of office is supposed to be there with you. Your oath is bonded by an amount of money. If anybody catches you breaking your oath, then you forfeit the bond to the person who catches you breaking your oath. That's how that works. When you are asked, are you serving under oath? If you are serving under oath, you have an obligation at law to say yes. And if you are asked, please recite your oath and tell me what your oath is, you are under obligation at law to recite the oath of office that is the office that you are operating at that time. You are under an obligation at law. Now, just to let you know that I understood this, I discussed this with the 2 Australian federal police officers who were sitting in the courtroom. I discussed this with them during the break in proceedings. Both officers, Christopher and Andrew, confirmed that they knew and they understood that the magistrate was required to say that he was operating under oath and required to recite his oath should I so ask him. They agreed and said that was the situation. They were federal officers. They had been trained. That's what they were required to do. Okay. So when I asked David whether he was serving under oath, and I asked him twice, I took a quick look over my left shoulder to see what those guys were looking like, and they were shocked and stunned. They were absolutely shocked and stunned. Okay? So they knew, they both knew, because I told them at the break that I was going to ask David this question, and I predicted at the break that David would try and run straight over the top of me and not answer the question. And both of them said no, he will answer the question because he's operating under oath. And they were shocked to the core. Now those 2 gentlemen should have immediately stood up and gone and arrested David Dunkley for the crime of impersonating a public officer, because that's the crime that he was committing at that point in time. So I have, to the right on the video, you will see about a dozen people sitting in the gallery, and to the left, my left rear, you see the 2 Australian federal police officers. Okay? So it is this video is an incredibly important piece of evidence. So I would suggest you watch it very closely. What I'm going to do before you watch it is I'm just going to walk through the script a little bit and make my comments, and then you can watch the video. Now clearly the video is presented as is. It was just done on a little handheld recorder, so you know we don't get to walk into court with great big video cameras and all the rest of it. That would have been confiscated. After I walked into the court, took my position, I pulled out a small handheld recorder. They're called flip recorders. They're about the size of a half pack of cigarettes, and so it was quite discreet. But it was understood that I was recording, and it's understood that it was understood that I was recording because in the court order that David Dunkley wrote, he claimed that it looked like I was recording the meeting on my cell phone or something like that. And the little flip recorders look very much like a small cell phone. Okay? So, you know, they're talking about transcript material in any form by any means without seeking proper prior permission of the family court, etc. This is all rubbish. Okay? This first piece is rubbish. This never happened. I did not address David Dunkley until I had my video recorder going. At that time, Jennifer and Sarah Bevan were already sitting in their seats. Nice of the courts to say that you cannot have a recording device, and then they will tell lies on their transcripts. So the transcript is, this part of the transcript is a lie. Okay? None of that happened. This is where the truth is starting to be told. I started out here. So this is where the truth is starting to be told. As you can see from the video evidence, I made this opening statement. These were the first words I spoke inside the courtroom. Okay? Now, I was nervous and confused as to what exactly was happening because I had never been in a situation before. I'd only been to court twice before, once to challenge a speeding fine from a lying police officer, and once to have my wife advise a magistrate that she had lied to the police in order to frighten me, and that ended up in me being arrested. Going to court like this was stressful and a difficult experience. I was also very jet lagged. I had actually flown from London to Sydney just 3 days earlier, in preparation for this meeting. So I had flown from London to Sydney. I was living in a hotel, and I was very jet lagged as well as stressed and all the rest of it. Okay. I also understood that I was placing my life at risk by walking into this court and video recording it, because what I was hoping to do in the court meeting was to catch David Dunkley committing a crime on video, which I did. He committed the crime of impersonating a public officer. When the trial of David Dunkley comes up, the jury will be asked to remember the circumstances under which I was taking on this criminal cartel, and that all mistakes were indeed honest mistakes. The fact that it is more than 3 years later now and no other man has emulated this achievement yet is testimony to the fact of how much courage and bravery it takes to walk into a court knowing you're risking your life and video recording what's going on and standing your ground. No other man has done that since in a family court matter, right? I rather thought that men would be following my lead quite readily. Okay, so any mistakes I made were honest mistakes. In the early part, I didn't realise that the courtroom was not the court, and that the court itself was beyond the balustrades, and that I never entered the court at any stage. David gave this away during the meeting. Okay, so from the video you can see I stand behind the balustrades, and I never at any time enter the court. I've entered the courtroom, but I've never entered the court. And at one stage David said, "Everybody can see you've entered the courtroom." And when he said, "Everybody can see you've entered the courtroom," I wondered why he said courtroom and not court. And then I looked where I was standing, and I noticed I was still outside the balustrades, and so I had never at any time entered the court. Okay, so never at any time can David Dunkley claim anything about obtaining jurisdiction. And in the court order, you will see David Dunkley actually claims that I at no time denied the jurisdiction of the court or challenged the jurisdiction of the court, which is ludicrous once you watch this video. So David makes many attempts to talk me into taking a seat and therefore, quote, boarding his ship, while all the while refusing to agree to the contract that I may do so with my property rights intact. He wanted to say that stepping into the court signified boarding his ship, and that he is the pirate of a captain's ship, and that's their interpretation of it, and by stepping into the court I would be waiving my property rights. That's what he was claiming. Now remember, on the 24th of November, 2 days earlier, I had issued the default judgment to Louise Henderson to say she did not have the right to have my house, have the proceeds of my house. Okay? So you can go through all this. So he's asking whether I'm relying on any documents, and I said I'm not relying on any other documents to do with the Australian Federal Magistrates Court, and the point is the court is a private company run for profit and control of the people. If you agree to use their documents, you agree to be a slave. And I had my documents to be delivered to David, remembering that Paul Large claimed 10 minutes before we went into the courtroom that he had given a copy of all my documents to David Dunkley. So on the video, which you are about to watch, when David Dunkley says, you know, this may proceed on an undefended basis, he already had copies of my documents. So he was lying while he's sitting there on the stand. Okay? He is again offering for me to waive my property rights. When you know what he's saying, it makes sense why he keeps offering. So those documents aren't relied on by you. If that's the case, then you won't have any documentation before the court. And my comment is I had documents to put before the common law court, but this court was operating in Uniform Commercial Code, and I had reused the jurisdiction of that commercial court. So he says, well, it's a matter for you either to give me the documents now or the case would proceed on an undefended basis, says David Dunkley. So undefended? Who says I'm accused of anything and need to defend myself from anything? Okay, so he's claiming that I may go forward on an undefended basis, but I'm not. What am I accused of that I need to defend? So you think about that. Why is he saying I need to defend myself? Okay. So I said to him, "You have no right to proceed with this case on an undefended basis, David. I have submitted my claim of right to the Queen, the Prime Minister, the Attorney General and the Governor General, and they have consented by acquiescence that you do not have a right to provide judicial," and I got a mistake, I've changed it to adjudication services to me unless I consent. Okay, so here I point out how David has no right to proceed in this meeting on an undefended basis, since the Queen et al. Had already agreed that these courts and their statutes have no authority over me. And if David is to claim authority over my property, he needs the Queen to explain why she did not rebut my affidavit and default judgment. Since he has a sworn allegiance to the Crown, he is beneath the Crown, and he must do as the Crown has agreed to. This statement is my clear rebuttal of the jurisdiction of David's private little court to force adjudication services over me and my property. It is in his order issued on the 19th of February 2010, David makes the claim that I at no time rebutted or challenged the jurisdiction of the court. Well, here it is in their transcript that I did this, and it is on the video evidence. This proves beyond doubt that David lied on his order as to the basis for his judgment. If men put up with such blatant lying by magistrates, they deserve their slavery. Please note the clear denial of right to provide adjudication services. I got it wrong in the first speaking and said judicial. Realising my mistake, I corrected myself to adjudication services. These courts offer to the public domain adjudication services, just like McDonald's offers hamburgers. And if you avail of their adjudication services, then you agree to their fees, which are astronomical by the way, and you agree to their decisions. Why would any man agree to this? These magistrates are there to apply common law, not this la land UCC rubbish they dish up. Okay? So David says, "Well, sir, you are an intelligent man and you know that's a nonsense." Here David calls my defence of my inalienable rights and my claims a nonsense. A nonsense, my inalienable rights. So I make him the offer of putting his words on an affidavit. Notice he refuses that offer, meaning he knows it's perjury. So I said to him, "Well, if that is a nonsense, David, you are going to have to sign an affidavit under full penalty of perjury, full commercial liability, to say that is a nonsense. Are you willing to sign such an affidavit?" And David said, "No, I have just said that is a nonsense now." And so he's trying to repeat it's a nonsense to make it stick, and this is a lie, and I knew it. And I said, "Well, what you say doesn't matter. What matters is what you are prepared to put on an affidavit, David." So David, knowing he has just lied, I point out what he says is not relevant. It only matters what he's willing to put on an affidavit. Okay, so he's trying to dismiss my defence of my inalienable rights as nonsense, and he's not prepared to put anything on an affidavit. He's just sitting there talking. And basically, he's sitting there as a Burger King or McDonald's magistrate. He has no jurisdiction, and he's telling lie after lie after lie. That's what's going on in this video. And he says, "Sir, you either hand me the documents now or the matter proceeds on an undefended basis." Notice the threat. He has no right to do this, and he knows it. So he tries to threaten me and frighten me. But I stick to my guns because I know he's a scumbag criminal. And I said, "Well, if you proceed with the matter on an undefended basis, David, I will charge you 1 million ounces of gold for enforcing an adjudication process on me that I have not consented to as a sovereign." Okay? So I was feeling far more confident and far better understanding what was happening by this stage. I decided to offer David a contract for 1 million ounces of gold to retain me in the room defending my rights. That's what that statement was about. And so I then said, he said, "Thank you." So I said, "I stand here before you as a sovereign of the nation of the land known as Australia, and I do not consent to your adjudication services in any way. So any way, shape or form, and I have plenty of witnesses who know this." So I just want to repeat this, reading this into the record for this case of Jennifer. I said, "I stand here before you as a sovereign of the nation of the land known as Australia, and I do not consent to your adjudication services in any way, shape or form, and I have plenty of witnesses who know this." Here is another clear rebuttal of the offer of adjudication services, again exposing the lies of the order of 2010-02-19, where David Dunkley claims that I never denied the jurisdiction of the court. Okay, there I am denying the jurisdiction of the court. And David says, all right, thank you. Then the matter proceeds undefended. And I said, well, you will be charged 1 million ounces of gold for doing this. David, do you agree to that charge? And here I made it very explicit that if he continues, he will be charged 1 million ounces of gold, and he is asked to enter into that contract. So let me just repeat this very carefully because it's very important. I said, well, you will be charged 1 million ounces of gold for doing this, David. Do you agree to that charge? And he said, and it's on video and in the transcript, charge whatever you like. Okay? Now, I distinctly remember he said, yes, charge whatever you like. The transcript service seems to have dropped the yes, and you can get it on the video, right? So, in order to confirm that the contract was entered into, I said, thank you for agreeing to the bill, David. Your audience here may wish to know why it is that a man cannot enter the courtroom with his inalienable rights intact. I was so astonished at the yes, I immediately wanted to make sure that the video recorded the fact he has agreed and give him a chance to object if he did not mean it. So I said, thank you for agreeing. Okay? So I said, thank you for agreeing. And your audience here may wish to know why it is that a man cannot enter the courtroom with his inalienable rights intact. So that constitutes a contract. He said, charge whatever you like. And I said, thank you for agreeing to the bill, David. And he didn't object. Okay? So in that interaction, which you will see on video in just a minute, David Dunkley agreed by contract for a bill of 1 million ounces of gold to provide his unwanted adjudication services to me. Okay? And also remembering that he had no right to be adjudicating on the property in the first place. Okay? So then David said something which gave the game away. I was still pretty confused at this point in time as to exactly what was happening, because it's meant to be confusing, right? David said, the audience here observes that you are already within the courtroom, sir. All right then, Miss Bevan, you better address me in respect of how we would get to a set of circumstances that would mean your client gets the totality of the asset pool, right? So my comment here is this. Now here is an important distinction which I had not gotten until David said this. He could not know I was still confused on this point at this point in time. I was standing just inside the door, which you can see on the video. I had been manoeuvred there covertly by only having one door open. I had intended to stand in the doorway, but while standing in the doorway, these criminal scumbags brought a crowd of students to watch the circus, and you can see to the right hand side in the video the crowd of students. I wonder what they made of it, right? So why did they bring a crowd of students in to watch this circus? Anyway, they were all standing behind me. I moved into the courtroom to allow the students in, and that was no accident. They did that to me. They were maneuvering me into the room, and then in this sentence, David tries to present in the courtroom as the same as being in the court, but it is not. The back area of the room is the public gallery, which is still, by the analogy, on land. The balustrade represents the edge of the ship. When David said this, I noticed that I was only in the courtroom and not in the court. This was a major victory for me and a major mistake by David to point this out. My confidence swelled as I realized what he had told me. Okay, I realized he had told me I was in the courtroom but not in the court. I was still standing in the public gallery at this point in time. Okay, so David gave that away. Now next, there's a lot of discussion during the court case. I will mention some things. Sarah Bevan said, finding in favour of the innocent party. And I want the jury to notice that the woman is the innocent party despite the crime she has committed. What does that make you the man? That makes you the man, the guilty party by presumption, because they're calling her the innocent party. But the question for the audience, the jury who is listening to this, what was I guilty of? Why was she the innocent party and why was I the guilty party? What was I guilty of? I was guilty of being a man, of course. Okay. So we'll go down a little bit further. So David Dunkley says, do you consent to the tender of the documents, meaning the documents by Sarah Bevan? And I said, no, I do not consent to the tender of the documents, David, meaning Jennifer's documents via Sarah Bevan. And David said, all right, on what basis don't you consent to the tender of the documents? And I said, I don't consent to the tender of the documents on the basis that I have not been given the opportunity to enter the court with all my inalienable rights intact. Okay? So I'm saying, I've asked you, David, many times over, and it's on the video, I'm quite happy to enter this court on the basis that you agree on the record, on my video, that I do so with all my inalienable rights intact, and you won't say yes to that. So I don't consent to the tender of Sarah Bevan's documents, Jennifer's documents, on the basis that I haven't been given the agreement to enter the court with all my inalienable rights intact. So everything presented by Sarah Bevan was not consented to and is dismissible. Okay? You, the jury, listening to this evidence, can dismiss anything presented by Sarah Bevan because David asked me if I consented to the tender of the documents and I said no. And so David tried to get out of it and he said, that's not a legal basis for the tender not to proceed, sir. And David tried to fool me on legalese. He's claimed that it's not legal, which is true, but I'm not subject to their legal system. So I said, that's the lawful basis for the tender not to proceed, David. And so I pointed out to David that my objection is the lawful basis, which is higher than legal basis not to proceed. So what does he do? He just ignores it. He says, all right then. And so I reminded him, I said, we are in common law jurisdiction, David. Okay? So he's saying that's not a legal basis, which is Uniform Commercial Code legal system, which is inferior to common law, and he went forward and tried to override me, and I pointed out to him, we are in common law jurisdiction, David, and when you get to the presentation by Robert McClelland, you will see Robert McClelland consistently references cases in Australia where the Magna Carta defines the basis of law in Australia and that the legislation must be consistent with that law. Okay? So you, as a layperson listening to this, you can speak to your expert in common law who will be assigned to you. He will tell you that Uniform Commercial Code must operate in harmony with the underlying system of law, and as far as the Commonwealth of Australia is concerned, the underlying system of law is the English common law founded on the Magna Carta. Okay? So I told David Dunkley that's the lawful basis for the tender not to proceed, David, and he proceeded anyway. So I told him we are in common law jurisdiction, David, and he proceeded anyway. Okay? Which he had no right to do. Okay, so then there was a break. In the break, I'd spent time talking to these two Australian federal police officers who said their callings were Christopher and Andrew. Amazing, because my middle name is Andrew and my oldest brother is Christopher, and I took that as a good sign. Anyway, I explained to them that this was all a lie and the courts were corrupt. I told them that in the second half I would challenge the magistrate as to whether he was under oath. One of the two, I forget which one by name, but it was a dark-haired one, said that magistrates were always under oath on the bench. I told him to watch what happened. What will happen. I told him that the magistrate would refuse to talk about whether he was under oath because he wasn't. I told him he was nothing but the captain of a pirate ship intent on plundering my property. He joked that they were just the hired hands and were there to do what the captain told them. These guys obviously understood that I was no, quote, threat of violence and that I was there as a patriot, though they also thought I was crazy. Okay? So it goes on and we do all this stuff, and you can probably properly read this for yourself. And I said, all right, do you want to do that now? And so, not in answer to that notice, I have plenty of documents that I wish to provide you. I was repeating, I have plenty of documents I wish to provide you. And he said, all right, do you want to do that now? Thank you. And I said, I would love to do that now, David, as long as you will agree that I can enter between these two gates with all my inalienable rights intact, in particular, my property rights. So I make another offer to, quote, board his ship with my rights intact and point out that I am particularly concerned about my property rights. Now, I was having real fun by now. By now, I knew I had him. I knew I had him on video, and I knew that I had won this particular battle. So he said, and be very careful about listening to this. You, the jury, listen to this carefully. He said, yes, all right. So if you are going to produce them now, please. So David gets even more slimy here. He says, yes, all right, but he is not clear what he has said yes to. So I make sure I ask him what he said yes to. So I said, when you said yes, all right, do you mean I may enter with my property rights and my inalienable rights intact, please, David? And he's caught out being a slimy bastard, and he says, no, I didn't mean that. I don't mean that. Okay? So here is his sliminess exposed. He meant yes to something else, but he would not elaborate what he was saying yes to. Okay? So are you men getting the picture in the audience? I say, I would love to do that now, David, as long as you will agree that I can enter between these two gates with all my inalienable rights intact, in particular my property rights. And he says, yes, all right. So if you are going to produce them now, please. And I notice that he's being slimy, and I say, when you said, yes, all right, do you mean that I may enter with my property rights and my inalienable rights intact, please, David? And he says, no, I don't mean that. Okay? So he's saying, no, I don't mean you can board my ship with your property rights intact. If you board my ship, I'm going to claim that you don't have your property rights intact. That's what that means. So I then say, may I ask you a question then, David? Okay? Remember, I'm the master, he's the servant. And he says, no. So I said very politely, may I ask you a question then, David? And he says, no. Are you going to produce some documents in answer to the notice to produce? So I then said into the record, so I want it recorded that I asked politely, may I ask David a question? And he said, no. And so then he said, are you going to produce the documents? Now remember, he's got a copy of these documents that I had in my bag. Okay? And he keeps pretending that he doesn't have that copy. And he keeps saying, no, you may not enter my court with your property rights intact. If you want to enter my court, you must give me all your property so I can adjudicate on it. That's what he's saying. Now, you may not understand that's what he's saying, but you can check with your expert in common law and he will tell you that's what he's saying. So then I say, because he said no to asking him a question politely, I then say, is your oath in the courtroom today, David? Okay? He is, by law, obliged to say yes. Okay? I said, is your oath in the courtroom today, David? And he says, all right, I take it that means you are not producing. He didn't answer the question. He avoided the question. So I said, and I note for the audience that David has refused to answer the question, is his oath in the courtroom today? So he's not a magistrate. He's not a magistrate. When you ask a magistrate or a judge, is your oath in the courtroom today? He is obliged by law to say yes. David did not say yes, therefore he was not a magistrate. And most likely his oath was not in the court that day. So I note for the audience that David has refused to answer the question, is his oath in the courtroom today? So there are no documents in answer to the notice to produce. And I said, there are documents in answer to that notice, David. However, I will only present those documents in the case that my inalienable rights are intact. And then they go off on a whole bunch of other stuff, right? And then right down the end, we'll just go down to the end. And you can read these comments if you want. So, down towards the end, he says, well, I'm going to reserve, so you will have to come back in respect of that. Mr. Nolan, are there any submissions that you want to make? And I said, David, I have asked you to call me Peter. Mr. Nolan is a corporate strawman of which I'm the primary creditor and secured party. And for the record, are we on the record? I believe you've been recording, I was saying to the girl at the side. And David says, no, what happens here, Mr. Nolan, is that all proceedings in this court are recorded. So I said, okay, so for and on the record, David, are you operating under your oath today? Okay, this is my little bombshell endgame. David, are you operating under oath today? He says, Mr. Nolan, do you have any submissions that you wish to make? And I said, for and on the record, David, are you operating under your oath today? And David refuses to respond, and I looked over my left shoulder at this time to see the two federal officers staggered at what was going on. David says, I take it that therefore you have no submission that you wish to make. And I said, so let the record show that a sovereign, Peter Andrew Nolan, has asked David twice, is he operating under his oath today? And David has refused to answer that he is operating under oath. And it is my contention that he is operating as a private employee and therefore has no jurisdiction over my common law property rights. David said, there being no submissions and I reserve my decision, I will deliver written judgment on a date to be advised. And I said, well, David, should you choose to violate my property rights, let me hereby notice you that I will address those rights in a common law jurisdiction court. You may be charged with theft, you may be charged with violation of common laws. I have with me documentation to demonstrate that I am the primary creditor of the corporate strawman, Peter Andrew Nolan, and I have the highest claim. I have not been able to present this documentation because the judge, and I meant magistrate, is acting, and I correct myself, the magistrate is acting as a private employee of a private company, not as a common law judge. He is in fact impersonating a public servant. And I read that into the record. So you, men sitting on the jury, David Dunkley was committing the crime of impersonating a public servant. That's what he was doing. And I have two Australian federal police officers by the name of Andrew and Christopher who witnessed that. Okay, all we need to do is find out from Paula Large who Andrew and Christopher were. So then there's a summary by me where you can go and read that. So this ends the reading of the transcript of the court meeting into the record of this case, and the next thing you will see is the entire video of the court meeting. Thank you very much for listening.
I did. There is one additional order on this minute order in relation to an county Jersey.
statement, which was sworn on the 20th of November.
That's correct,
Is
Your Honour.
that the documents?
They are.
Now, Mr. Nolan, there was filed for you an application for final orders on the 3rd of December 2007, and there was also filed on that day an affidavit that you swore on the 13th of June 2008, and a financial statement that you swore on the 28th of November 2007. And there don't appear to be any updating documents since then. Are you relying on any other documents?
I'm not relying on any other documents to do with the Australian Federal Magistrates Court.
You're relying on those or not on those?
I'm not relying on those documents to deal with this situation today, and the question I have is, may I take a seat with my inalienable rights intact?
You can take a seat whenever you like.
When you agree that my inalienable rights are intact, I will take a seat, Your Honour.
It's a matter for you as to whether you keep standing. So those documents aren't relied on by you. If that's the case, then you won't have any documentation before the court.
I have documentation to present before a common law court, Your Honour, but I'm not going to enter until such time as you agree to the contract that my inalienable rights are intact.
Well, it's a matter that you either give me the documents now or the case would proceed on an undefended basis.
You have no right to proceed with the case on an undefended basis, David. I have submitted my claim of right to the Queen, the Prime Minister, the Attorney General and the Governor General, and they have consented by acquiescence that you do not have a right to provide judicial adjudication services to me unless I consent.
Yes, well, sir, you're an intelligent man and you know that that's a nonsense.
Well, if that is a nonsense, David, you are going to have to sign an affidavit under full penalty of perjury, full commercial liability, to say that it is a nonsense. Are you willing to sign such an affidavit?
No, I just said that it is a nonsense.
Well, what you say doesn't matter. What matters is what you're prepared to put on an affidavit, David.
All right, so there's no documents on which you seek to rely.
I have documents on which I seek to rely, but you have not agreed to the contract that I can enter the courtroom with my inalienable rights intact.
So you either hand me the documents now or the matter proceeds on an undefended basis.
Well, if you proceed with the matter on an undefended basis, David, I will charge you 1 million ounces of gold for enforcing an adjudication process on me that I have not consented to as a sovereign. I stand here before you as a sovereign of the nation of the land known as Australia, and I do not consent to your adjudication services in any way, shape or form. And I have plenty of witnesses who know this.
All right, thank you. Then the matter proceeds undefended.
Well, you will be charged 1 million ounces of gold for doing this, David. Do you agree to that charge?
Charge whatever you like.
Thank you for agreeing to the bill, David. Your audience here may wish to know, why is it that a man cannot enter the courtroom with his inalienable rights intact?
The audience here observes that you're already within the courtroom, sir. All right, then, Ms. Bevan, you better address me in respect of how we would get to a set of circumstances that would mean that your client gets the totality of the asset.
In order to do that, Your Honour, I must tender a reasonably significant amount of documentation. In relation to Button-Keller and Weir principles, my case is that the husband, by failing to disclose his assets, has left the court in a situation where, as those cases say, you should not be unduly cautious in making an adverse finding in favour of the innocent party. In addition, Your Honour, the husband himself in various emails has made reference to his own income earning ability, in reference to his obstruction of the company of the parties, instant business intelligence. There are other factors to take into account with regard to the Irish proceedings. My client's evidence is those Irish proceedings are now concluded and cannot be reinstated.
Well, they can't be because, I mean, this is the venue for the hearing.
It is. This is the appropriate jurisdiction, I must admit, Your Honour. Your Honour, there's also emails from the husband in which he makes reference to having removed certain amounts of money, such as €7,000 and €10,000 out of the jurisdiction, that being the jurisdiction of Ireland.
Well, we better tender that material.
Thank you, Your Honour. I have on the front of it a list of those documents. I estimate that it would take you approximately an hour to read. However, I can indicate that in relation to the husband's emails, although it's certainly outside of the usual practice, those emails are quite lengthy and I have put highlights around the relevant sections. I don't ask you to read the whole of the emails, but simply those highlighted sections.
So, the material that's produced in the greenback folder, you're seeking to tender that?
I am, Your Honour.
Mr. Nolan, there's sought to be tendered before me some material in a binder. Do you wish to be heard in respect to the tender?
I do wish to be heard, sir, and I wish you to agree that I can approach the court with all my inalienable rights intact.
So, do you consent to the tender of the documents?
No, I do not consent to the tender of the documents, David.
On what basis don't you consent to the tender of the documents?
I don't consent to the tender of the documents on the basis that I have not been given the opportunity to enter the court with all my inalienable rights intact.
That's not a legal basis for the tender not to proceed, sir.
That's the lawful basis for the tender not to proceed, David. We are in common law jurisdiction, David.
And on the basis that there's no objection that is sustainable at law, I mark as Exhibit A the material in a ringback folder. Yes? Anything further, Ms. Bennett?
Would you have my submissions now or after
I
you've
know I better read all of that material.
Thank you, Your Honour.
All right, we'll adjourn while I go off and read.
On stand, please.
This honourable court stands temporarily adjourned.
Now, thank you.
I would love to do that now, David, as long as you will agree that I can enter between these two gates with all my inalienable rights intact, in particular my property rights.
Yes, all right. So, if you're going to produce them now, please.
When you said yes or right, do you mean that I may enter with my property rights and my inalienable rights intact, please, David?
No, I don't mean that.
May I ask you a question then, David?
No, are you going to produce some documents in answer to the notice to produce?
So I want it recorded that I asked politely, may I ask David a question? And he said no.
Are you going to produce the documents?
Is your oath in the courtroom today, David?
All right, I take it that means that you're not producing.
And I note for the audience that David has refused to answer the question, is his oath in the courtroom today?
So there's no documents in answer to the notice to produce.
There are documents in answer to that notice, David. However, I will only present those documents in the case that my inalienable rights are intact.
Yes, Ms. Bevan.
Thank you, Your Honour. Your Honour, in the documents produced, tendered, there wasn't a reference to the €10,000, I believe. I have one email and one letter to tender in addition in relation to that. It's only the upper part of that email that's in region.
Mr. Nolan, there's
David, I would like to participate in a friendly and peaceful way in this conversation. However, I'll only participate in this conversation with my inalienable rights intact. By the way, I wish to declare that Mr. Peter Andrew Nolan is a corporate strawman fiction, and I'm the primary creditor and secured party for this corporate fiction. You may call me Peter, David.
I marked as Exhibit B the email from Sarah Bevan dated the 25th of November 2009 to SBA Mail. Mr. Nolan, there is a letter from the Royal Bank of Canada to Mrs. J. Nolan dated the 20th of March 2008 that sought to be tendered. Do you want to be heard about that?
David, I've asked you to please call me Peter. Mr. Nolan is a corporate strawman. It's a dead entity. I will speak as Peter Andrew of the Nolan family, the primary creditor and the secured party for the corporate strawman, Mr. Peter Andrew Nolan.
And there being no objection, I mark as Exhibit C the letter from the Royal Bank of Canada dated the 20th of March 2008 to Mrs. J. Nolan. Ms. Bevan, reading the material, there's an email called dublinolans@gmail.com. I presume that's your client's email.
It is your own, yes.
And then there's some emails to a bruce@gsco.ie. Who's that person?
There was only one to Bruce, and that was the accountant
The accountant for what?
for instant business intelligence.
And there was some emails directed to a Bill Toll, T-O-A-L.
My client's side. The others, which is Jarrow backwards, Robertson is my client's son.
Yes, all right, and your submissions.
Thank you, Your Honour. The orders my client seeks effects when one takes into account the add-backs included. And in that relation, that regard, Your Honour, I should have an amended case outline, which I should have handed up earlier. There are only some minor amendments on it, which I've underlined, is to add in one add-back of $7,000.
That's the money that was transferred.
7,000 euro, yes, was. And the net is underlined on the two last pages. Your Honour.
Yes.
Your Honour, the effect of the orders sought by my client, if the add-backs are taken into account, and I'll address you on those shortly, effects a split to my client of the assets of 83%, 83.3 to be precise. My submissions take two alternative approaches, or indeed a combination of both. That is, that these orders are warranted on the basis of a Black and Kellner or Weir type approach, as I highlighted earlier, that being that the court should not be unduly cautious in making findings in favour of my client as a party. The alternative is that there should be a significant adjustment pursuant to section 75(2), specifically in relation to subsection B. Your Honour, in relation to the assets, the Australian assets and the relatively minor assets in Ireland are easy to identify. There is also, the husband asserts in emails, a loan from his brother. The wife has given evidence that that loan was in fact a gift. And the husband's own emails, as contained in the tender documents, refers to that amount not needing to be paid back.
It's not a judge's contribution that comes in on his side.
You do, Your Honour, and I'll address your contributions in that relation, in that respect when I get to it. But given that the husband has not put any evidence with regard to the amount of the loan, or the interest on the loan, or the terms of repayment, and also given the nature of his emails as contained in the tender Exhibit A, my submission is that this is not a loan, it should not be treated as a loan of the parties. In fact, it's just simply a contribution issue that I'll come back to. You're in relation to the Black and Kellner considerations, you have before you emails from the husband where he refers to removing €7,000 out of the jurisdiction. He also refers to paying that amount to a colleague in Germany, as he says. You also have the email Exhibit B, which refers to him removing €10,000. He says to apply it for the sake of the family. My client's evidence says different. And in fact, my client's evidence is the only sworn evidence you have before you, Your Honour. In addition, Your Honour, there was also what I would submit was a very significant asset, that being the company Instant Business Intelligence. My client's evidence is clear that that business traded well, afforded them a very decent income.
No, I don't have any figures about it.
You don't?
There's no profit and loss statements. There's no
You have-
taxation return.
You have nothing in that regard, Your Honour. My submission in that respect is that you cannot know anything about the company. And in fact, the company is now dissolved.
Dissolved, sort of.
But in any event, there's no means by which that this court can say, I consider it had, or at some stage, a value of X. That,
I mean, it could simply just be a trading company that they conducted a business in. It had no other intrinsic value of its own.
as in just a simply income-earning vehicle.
Yeah.
It could, Your Honour, but it also could have been a significant asset itself. Tied in with the company is the reference the husband makes in various emails to the software, that he has software. And one of his emails refers to, no court can force me to sell my software. My submission in that regard, Your Honour, is that he's making a concession that there is an asset. Again, you have absolutely no means of knowing what that asset is worth. And that is because of the husband's complete failure to disclose any relevant material in this case, Your Honour. You're in circumstances where you have no knowledge of what the asset pool is. This is a case in my submission that falls clearly within the guidelines set out in Weir and Wee, and in my submission should give you, or should lead you to not be cautious at all in making findings in favour of my client. When I referred earlier to my client receiving 83% of the property pool, that is of what we know there is, and the easily identifiable add-backs. Your Honour, in respect of the add-backs, it's my submission that where you have, in effect, concessions by the husband, that those amounts have been removed for his own purpose, have not been expended on my client's evidence for the sake of the family, but presumably have been used for his own personal purposes, or simply, as he says, paid to someone else, that being a colleague in Germany, then the appropriate course is to treat those as add-backs rather than as some sort of wastage consideration under Cavalli. Your Honour, in relation to, actually I'll come back to the Cavalli issue later, Your Honour. In relation to those add-backs, there is then the consideration of whether they are to be treated as an asset rather than under Section 75(2). In that regard, given that the amounts are clearly identifiable, and my client's financial statement sets out the means by which he has converted the amounts to Australian dollars, that being 1.616, I believe, it is appropriate, and in fact is really the only course open to the court in respect of how to treat those factors. Your Honour, in relation to the contributions, my submission is that this is a case where there should be a 55-45% split in my client's favour. Your Honour, the husband, if he was to present a case, might have two factors that he could argue in relation to contributions. That being that he provided support to the wife's two older children from a previous relationship.
A Robert Rob type argument.
Sorry?
A Robert Rob
Yes.
type argument.
However, that's mitigated by the fact, Your Honour, that my client received child support from the children's father, and they were only resident with the parties for a limited part of the marriage. The other factor, Your Honour, is the gift from his brother. He said it's a loan, but as my submissions made earlier, it's appropriate to be treated as a gift. My client's evidence is its amount of $15,000 that was advanced very early in the relationship. On the basis of it being a relatively limited amount and the amount of time and the nature of the contributions that have flowed since that time, my submission is it would really have little, if any, weight pursuant to his and his considerations, Your Honour. On the contrary, Your Honour, my client has made significant post-separation contributions. And I should add, when I'm jumping to post-separation, apart from those two factors that I've just mentioned, I would say that the contributions during the marriage would generally be considered 50-50. The husband was the breadwinner, my client was the care of the children and the domestic duties. She did that, and that's how the parties organised their lives. It's a clear case where, apart from these other factors, it would otherwise be a 50-50 case, Your Honour. Since separation, my client has continued to care for the children and has continued to make all payments for the care of the children. She's given evidence that in caring for the children, she must pay private school fees. And she's now also supporting Josephine, the older child, who is now at university.
She's over 18.
Sorry?
She's over 18.
She is over 18.
She's a special needs child.
She's not a special needs child, no. I will come back to her in relation to Section 75(2), though, Your Honour. In addition, the contributions that my client has made post-separation, in my submission, have been made more onerous by the conduct of the husband. The husband has embarked on a course of conduct which is designed, or I'll draw that. The husband's embarked on a course of conduct which has had a significantly negative effect on my client. She says in her affidavit that she's received an extraordinary amount of emails from the husband. And on that point, Your Honour, I must correct one point in my client's affidavit. She says she's received what numbers in the thousands. Since swearing the affidavit, she's taken the arduous task of actually counting those that she still has, not knowing if any were deleted when the husband accessed her account. And she has counted 550. That doesn't include the emails sent by the husband to various friends and colleagues and family members. Whatever the number, whether it's 550 or in the thousands, it is an extraordinary number of emails, all taking a very particular approach, and all the combined effect must have an effect on my client. You don't have in evidence, but my client instructs me today that she'd been in counselling for 18 months, we've now concluded that counselling, in order to deal with the treatment she's had at the hands of the husband. Your Honour, as you'd be aware, Canon and Canon gives authority to where, in circumstances where there's been domestic violence, but not only domestic violence, also other conduct, which is not limited by description. The factors such as those should warrant a consideration of weighting the contributions in favour of the, essentially the victim. Your Honour, if ever a case fell into the category of conduct which is designed to, or which has led to making the innocent party have a more onerous job in doing their day-to-day life, this is the case. The number of those emails, the nature of those emails, the widespread nature of those emails can only have an effect on my client. Admittedly, you don't have expert evidence before you, but in my submissions, it's a very clear-cut case that by simple common sense, the effect of those must have had on my client. Your Honour, in relation to Section 75(2) factors, my submission is that there would be a very weighty adjustment in my client's favour. If we started from a proposition of 55-45 contributions, my submission would be that it would be appropriate to adjust perhaps even by up to 40% in my client's favour. Your Honour, the subsection B refers to the income and earning capacity husband, throughout his emails, has referred to his income earning capacity. In one of his more recent emails, he's referred to the ability to earn €200,000. That, in rough figures, equates to, getting figures in my head, about 320,000 Australian dollars a year. He's referred to his consulting fee of €1,000 a day, which is 1,600 approximately a day, Australian dollars a day. If you don't consider that the property, that the business is indeed property, and instead was an income earning vehicle, the fact of the husband's income earning during the relationship suggests that he now has that earning capacity now. Whether he chooses to exercise that or not, as a result of other conduct that he chooses to take, is a matter for him. However, he has that capacity. Your Honour, in addition, my client has the care of the younger child from marriage, who's under 16. As her evidence says, she's required to pay private school fees for him, and also maintain him in the usual way. In addition, subsection D refers to the commitment to support others, as does subsection E. She's given evidence that she's paying Josephine's university fees. As someone on a student permit, she has limited work rights and therefore limited ability to support herself. In addition, Your Honour, subsection K refers to the effect of marriage on the earning capacity of the party. My client gives evidence that throughout the marriage, from very shortly after the younger child's birth, by agreement, she was the one looking after the children. She was the one who stayed home and devoted herself to the care of the children in the house, and effectively enabled the husband to go out and earn the amounts of money that he did, which then puts him in good stead to earn the same similar amounts of money now.
I just don't have any evidence as to what he earned.
What he earned. In my client's affidavit, Your Honour, there is some evidence.
It's a statement.
There is limited evidence, but we have it before you in paragraphs 55 and 56. It's within her knowledge to make those statements, and therefore, as the only evidence we have in this matter, my submission is that it's strong evidence that you're able to rely on, Your Honour. She says that the company paid the husband between €6,000 and €8,000 a month, so €6,000 and €8,000 a month. And that the company earned $220,000 in consulting fees, an additional amount in software sales. Coming back to the effect of the marriage on my client's earning capacity, the absence for her from the workforce for such a length of time can only have a negative effect on her earning capacity. Subsequent to separation, she obtained work as a carer, which is a relatively unskilled position, and now works in office administration. She's detailed what her income is, and it's certainly not anywhere near what she says the husband's income was. Your Honour, another consideration under Section 752 is the child support paid by child support paid for the children. Josephine is now over 18, but she was under 18 at the time of separation. Joshua is still under 18. My client's evidence is that apart from 3 payments in November 2007, she's received no money whatsoever for the children. She has had to maintain the children since separation, and I think it's very clear, my submission is there is no hope that the wife will ever receive any child support for Joshua. Your Honour, turning lastly to Section 752O, I mentioned before the Cavalli principles in respect to wastage. Your Honour, the husband has engaged in conduct that I would submit falls within the Cavalli principles in relation to two items. That being the company, if Your Honour accepts or is willing to make a finding that it may well have had a value, then the husband's assets, the husband's actions since separation have led it to now be dissolved, and for it to In addition, Your Honour has evidence about the actions the husband took in relation to the controlled monies account. The sale proceeds from the sale of the tenant Phil's property were pursuant to orders of 16 June 2008 to be placed in the controlled monies account.
The best that they can get for that would be something like about 2 or 3%.
In a cash management account, it now has gone up previously, which is relates to most of the period, would be about 3%. By my calculations, being that it's approximately 6 months, it would be around about $4,500. Your Honour, there's very clear evidence from the husband's emails in respect to the controlled monies. I can say that there was an attempt by my client to have the registrars sign the required documents pursuant to section 106A. There was a difficulty in that regard as a result of the notation made by Judicial Registrar Johnston that the agreement that Watson Prey would keep it, the husband's former lawyers, was a notation only. That was therefore unsuccessful, Your Honour.
That probably brings it to an end.
Sorry?
That probably puts it to an end. Yeah, but if it's a notation only, I mean, I'll have to look at that.
It's unfortunate that in what happened it was only notation. There was certainly no issue at the time, and it wasn't, that particular part wasn't drafted as consent orders, it was added by Judicial Registrar Johnston. Your Honour, turning lastly to justice and equity in respect to the property issues. While my client's application for effectively 83% of the assets is under what I have suggested might be the appropriate percentage for her, it is all that she can get. There is absolutely no point in making an order for the husband to pay her any money, because I think we can all accept that that simply will not happen based on the conduct of the husband to date. Your Honour, the husband has chosen not to give evidence today. It can be as a result of what can only be described his contemptuous attitude towards this court. That the husband is presented with that attitude should leave the court no concerns as to failing the husband in terms of providing him justice and equity. Your Honour, there are 2 additional orders sought that have only lately been sought in respect to parenting. Your Honour, that is sole parental responsibility and an issue about the passport. While sole parental responsibility should cover a passport, it's certainly my experience in the past with other clients that the passport office doesn't necessarily accept the sole parental responsibility order.
When does the child's passport expire?
The child's passport expires in January, Your Honour.
Travels on an Australian passport.
He does, Your Honour. Your Honour, there has been no Section 60I certificate. My submission is that this is a matter where mediation is, the requirement for mediation should be waived because of the simple impracticality of it. Your Honour, the husband, the only evidence I'm relying on in wanting to support the sole parental responsibility is the husband's own emails, where he refers to the children as his former children and also makes a comment of the leeches called wife and children. The husband himself has disowned the children. I can say to you, Your Honour, that those 2 emails that I provided you are not the only. There are only emails in that regard. There are numerous emails. I didn't see any point in tendering all of those for all the emails, Your Honour. Your Honour, those are my submissions. I do have an application in this separate cost though.
I'm going to reserve Mr. Nolan, are there any submissions that you want to make?
David, I've asked you to call me Peter. Mr. Nolan is a corporate strawman of which I'm the primary creditor and secured party. For the record, are we on the record? I believe you have been recording, madam. I believe you have been recording.
No. What happens here, Mr. Nolan, is that all proceedings in this court are recorded.
Okay, so for and on the record. David, are you operating under your oath today?
Mr. Nolan, do you have any submissions that you wish to make?
For and on the record, David, are you operating under your oath today?
I take it that therefore you have no submissions that you wish to make.
So let the record show that the sovereign, Peter Andrew Nolan, has asked David twice, is he operating under his oath today? And David has refused to answer, is he operating under oath? It's my contention that he's operating as a private employee and therefore has no jurisdiction over my common law property rights.
There being no submissions, then I reserve my decision. I believe a written judgment on a date to be advised.
Well, David, should you choose to violate my property rights, let me hereby notice you that I will address those rights in a common law jurisdiction court. You may be charged with theft. You may be charged with violation of common laws. I have with me documentation to demonstrate that I am the primary creditor of the corporate strawman, Mr. Peter Andrew Nolan, and I have the highest claim. I have not been able to present this documentation because the judge is acting, magistrate is acting as a private employee of a private company, not as a common law judge. He is in fact impersonating a public servant.